Good afternoon, everybody. I'm Joey Wender, the Executive Director of the SHLB Coalition. It's my pleasure to welcome everyone to today's webinar entitled Debriefing the SCOTUS USF Oral Arguments. I'm also joined on this webinar by Kristen Corra, our outstanding policy counsel, who will co-moderate this webinar with me. As you already know, the SHLB Coalition's been leading the charge in court to protect and preserve the Universal Service Fund. Shelby filed as an intervener in the 5th, 6th, and 11th Circuit, and we won in the 6th and 11th, but we lost in the 5th on a rehearing. That's why, in part, the Supreme Court took this case and did grant Shelby's cert petition to resolve this case in the split amongst the courts. And so with the support of the HWG law firm, Shelby filed an opening brief and a reply brief with the Supreme Court earlier this year, along with our great friends, NDIA, Benton, and Media Justice. And just last week, SCOTUS heard the oral arguments. Not only were Kristen and I in the room, along with both of our distinguished speakers, but our brief was explicitly cited during the oral arguments, which was quite exciting. So this webinar will help our audience understand what happened in the oral arguments and what come next. That's why we've gathered, again, two outstanding legal experts to help us understand what to expect as the decision is handed down early this summer. Jason Neal is with the HWG law firm and has been Shelby's lead attorney, drafting our court briefs and providing excellent legal advice. In addition, we have the renowned public interest advocate, Andy Schwartzman. We look forward to hearing their take in just a few moments. But before we get started, a couple housekeeping items. One, this webinar is being recorded and will be available on our website afterwards. Audience members are muted, but we encourage you to use the Q&A box, not the chat box, but the Q&A box to send us your questions. And as always, you can follow us on social media at Shelby Coalition or hashtag Shelby Webinars. Also, I want to explicitly thank our corporate sponsors, Ready, Zayo, T-Mobile, and Cisco. We would not be able to engage in this important work without their tremendous financial support. All right, it's time to hear from the lawyers about what they observed and what their conclusions are on what happened last week at the Supreme Court. So we will start with Jason Neal. Jason, the floor is yours.
Thanks, Joey. Thank you, as always, for the kind words and the opportunity to represent Shelby in such an important case. It has been a long road, and I've said many times it's simultaneously exciting to be at the Supreme Court on the future of USF, and it's also scary to be at the Supreme Court on the future of USF. So I know folks are really interested in how the argument went and kind of what comes from here. I think Andy and I both said this in the pre-brief, I'll call it. We never overread what happens in an oral argument for a reason. The justices and even judges on other courts ask questions about the things that they are interested in. Often you can kind of draw inferences about where they're at, but the judge who peppers you with questions and scowls at you all day sometimes writes the opinion in your favor and sometimes the exact opposite. So with that caveat, this is a good day. It's a good day for our side. I think the attorneys arguing for our side of the case, the acting solicitor general and Paul Clement, who represents the industry associations that we've been aligned with as the case has progressed, both, in my view, did a really fantastic job defending the universal service, explaining how the statute works, explaining how the fund works, and highlighting the importance of the programs for, rural Americans, community anchor institutions, across the country. The argument was very long for folks who have not listened or, God forbid, tried to read the transcript, maybe before you were going to bed. The argument was about 2.5 hours long. And the way that the sequencing goes, the acting solicitor general started, the justices let you speak for just about a minute, and then it's all questions. So appellate advocacy is an interesting thing where often you come in with, 3 or 4 key points you really want to get across. But ultimately, your job is to listen to the questions that you get, try to understand what's behind the questions, what's the concern that the judge, or in this case, the justice, is trying to get help with, and be as helpful as you can. So you always try to return to your key points, but ultimately it's you try to have a conversation with them and try to address what they have. Here, there were questions from across the bench, all 9 justices, asking a wide variety of questions. I think we'll get probably more into the substance. But one thing that really stood out to me is just how engaged all of the justices were in the weeds on this, that I think they all understood. I think we would say some of them understood in a way that is more in line with how we see the way that things work. But they understood, that there's a lot of history here, a lot of work that has happened at the FCC on how the programs function. And the Supreme Court had the Wisconsin Bell case earlier this term that also involved the E-rate program. So I wonder if that actually kind of helped them be a little bit more familiar with the ins and outs of the Universal Service Fund. But they were all just really engaged with this. So that was heartening. Again, we'll see where the case goes. I'll hand the mic to Andy in just a minute. I'll say, as we start to think about possible outcomes, the conventional wisdom about the court right now, at least in kind of hard or contentious cases, often is to think about the court as divided 3-3-3. You have Justices Thomas, Alito, and Gorsuch, then the Chief Justice, Justice Kavanaugh, and Justice Barrett in the middle, and Justices Kagan, Sotomayor, and Jackson. And that's not to say that, it breaks down, right, moderate, left, but the way that the votes tend to cluster in these cases, it's often the case that in these hard cases, the winning side needs 2 of the Chief Justice, Kavanaugh, and Barrett. And I think that that is as good a place to start as any in thinking about the outcome of this case. I think generally the questions that we got from all of the justices reflect kind of the 3 on one side and the 3 on the other, and then kind of the 3 in the middle. Again, it's just a heuristic that can be helpful in thinking about this, but I do think it's at least a good starting point. And I will say, before I do hand it over to Andy, in trying to win over those 3 justices, from whom we need 2, or let's cross our fingers and hope for 3, in trying to get those votes, I think Paul Clement in particular did a really fantastic job of addressing their concerns, giving them the history, giving them information on the programs. And again, it's, he was hired for a reason. He's argued more Supreme Court cases than just about anybody who's currently arguing at the Supreme Court right now. The justices respect him. They understand that he gets it, where they're coming from. And it was just really privileged to be in the room for that kind of conversation, that back and forth. So I think it was really helpful. And I will stop there until we get into the questions.
Perfect, Jason. Thank you for setting the scene. Andy, take it away.
Okay, but first of all, there is a clear consensus from the commentary, from the various articles discussing the oral argument and talking among our lawyer friends, that this went very well, and we can fairly confidently expect a favorable outcome and not an outright disaster. However, as Jason signaled, there have been surprises. We have all had cases. I had a case in the Supreme Court about 30 years ago, where you walked out of court thinking one thing was going to happen and a very different thing actually happened. So let's not do our high fives too prematurely. That said, I would also add that there's a number of possible outcomes given the way this case went. One possible outcome, well, back up for a second. What became fairly clear during the oral argument was that this to the extent that this non-delegation doctrine is something that some members of the court want to revisit, it was clear that probably a majority of the court agreed that this was the wrong case to do some major surgery on this constitutional doctrine, which is why we're probably going to come out okay. And that leads to possibility of some very unusual outcomes. For example, unlikely, but I wouldn't be surprised if there was a decision joined by mostly, perhaps even unanimous decision that would be very short, with or a plurality decision of 3 or 4 justices, and then 4, 5, 6, 7, 8, or even 9 separate concurring statements with different kinds of views on what should happen in the future. This wasn't the right case, but we need to revisit the non-delegation doctrine and the intelligible principle standard been in place for 80 years and so forth. So there's some very unusual possible outcomes there. I'm also going to just, before I turn it back to Jason, a little bit of color, because people really do enjoy this. The Supreme Court oral arguments, and this, although it was a very long one, this was otherwise a really good example of what a good Supreme Court argument could be like. You understood where the justices were coming from, their questions were very clear, and you get a real view of how 1/3 of the power of the constitutional governance operates in one relatively small courtroom. I haven't been in much bigger courtrooms than the Supreme Court courtroom. And also the seating of it, this was especially fun for me, and Jason probably almost as much so. One way to get seats, and we had a bunch of people, we needed to get seats from, and there's a very limited number of seats for the public, is to move someone for admission to the bar of the court, which is what Jason and I both did. And I moved my wife in. I've been saving her for an oral argument when I really needed a seat. And as it happened, I got a seat. It was technically the second row, but there was nobody in front of me, so it was effectively the first row on the aisle in the middle of the court. So I was 10, 12 feet from the Chief Justice, staring down at me in the front row, right behind where the counsel for the other side sat. And I just got to watch the best seat in the house. It was just great fun. And Jason was a couple seats over. It wasn't quite as good. It would have been a few dollars less on StubHub. It was just a great opportunity to watch these advocates in action. It was also interesting because, as we've indicated, this was not the best case to have been brought, and watching counsel for the other side squirm up close was kind of fun. I will admit to a certain kind of schadenfreude about watching him struggle, because he really could not effectively defend some of the core principles. Let me follow just one substantive thing before we get deep into the argument properly, which was the central question in the case is whether Section 254 of the Communications Act provides adequate guidance and limitations for the Federal Communications Commission to constitute what under current principles is an intelligible principle for an agency to exercise delegated authority, or whether it's just this unbounded blank. Yeah. And one of the things that we had talked about, I think, in the early webinar, was a critical element of this was the FCC is directed to provide sufficient funds to operate the program. And this word sufficient, as some of us expected, turned out to be a critical element in the oral argument. Is sufficient mean just a floor? It must be at least as much, or is it also a ceiling, no more than a certain amount? And I think the killer moment in the oral argument was when Justice Kagan was asking the counsel for consumers research on the other side about the term sufficient, and he was trying to argue that sufficient was just a blank check. And she said, but if I call and order pizza sufficient for 10 people, and an 18-wheeler filled with pizza rolls up, that's not what anybody would understand sufficient to mean. And he really did not have an answer for that. And I thought at that moment, I took a kind of deep breath and said, okay, we're going to be okay. Because I think that got across to the other members of the court. We can talk a little bit about how the split might come out and how some of the middle three justices might play. Even Justice Alito in the conservative brief seemed to understand that this was the wrong case and that there would be a lot of chaos could befall everyone if they went the other way. So I am cautiously optimistic, but remind you the proviso I started with.
Thank you, Andy. And while we're on this, I just want to go back to Jason. Talk more about this concept of a cap, right? So the sufficiency I was in the courtroom too, and Andy, I also had a front row seat. I might not have been 12 feet from the Chief Justice, but I was 12 feet from Justice Coney Barrett. So I got a very good view of what was happening. Jason, talk about the cap, because part of this conversation went to, well, what if there was a $1 trillion cap? What if there was a $3 trillion cap? Would that be sufficient? And so talk about what consumers research response was, and then obviously then talk about what the justices reacted with, in particular, Justice Barrett.
Sure, happy to do that. I think to set the stage for this discussion of a cap, it really goes to Andy's point that the core theme of the argument was, has Congress made the key decisions here? And to what extent is one of those key decisions how much money is necessary for USF? And the two sides of the case just kind of have fundamentally different views on that. The other side has argued Section 254 is kind of, has a lot of words, but not a lot of constraints. It leaves the FCC way too much latitude to raise as much as it wants for USF, raise even more than it would need for the USF programs potentially, just sort of, run wild with very little direction. And we and the government have emphasized that the statute describes the programs that go into USF, that there are very, very particular directions about how those programs work and principles for how to define universal service. And as Andy said, there's this concept a couple of times in the statute about funding that is sufficient for those programs. So the key question here is, when it comes to the size of the fund, has Congress made the key decisions? And the position of consumers research in their briefs and in the oral argument was, Congress must set some kind of a cap to have made that decision. Nothing else will do. I think that that's their position. So Congress has to pick a number or a rate or something. I think, they tried to say something objective, not qualitative based on the statute. And if it did, all of their constitutional arguments would just fall away. And we pointed out, and I think the justices picked up on, that it's a little bit odd for their argument to be, this statute doesn't constrain the FCC at all. It leaves the FCC way too free to do what it wants with universal service. But if Congress just picks a number, then it's fine. It's, anything under that number, the FCC can do seemingly whatever it wants according to their view, but they'd be fine with that. And so one of the hypotheticals that the government raised and then the justices picked up on was, okay, well, how big could the cap be? Could it be $500 billion, $1 trillion? Would you actually be satisfied if they said, if Congress, not even appropriating money, but told the FCC, you can collect up to $1 trillion for universal service and then do whatever you want with it? And the attorney for consumers research is sort of stuck in their position with saying, yeah, I think we'd be fine with that. At least at that point, Congress would have made the decision that, it's worth up to $1 trillion to us. And Justice Barrett in particular seemed not very pleased with that answer. Again, the caveat that we never know what people are going to do, but she just seemed kind of puzzled. And she said, that sounds pretty hollow. Like this would be meaningless exercise. She and Justice Kavanaugh both really pressed the attorney for consumers research on this, that, what are we doing here if all of these problems that you're identifying could be solved by $1 trillion cap that is effectively no cap at all, that would be good enough. So I think that Supreme Court arguments are not about who scores the best rhetorical points in the argument. It's ultimately, we have to get the justices to a place where they can write or join an opinion upholding the statute. But that, I think, was a big moment in trying to kind of highlight the problems with the other side's arguments. And that's really, really key for the case. And Justice Kavanaugh, along the same lines, said to the attorney for consumers research, I think you really need to hone in on this idea of sufficiency and tell me why, if $1 trillion cap would be a big enough constraint, why isn't it enough of a constraint? $1 trillion is effectively no limit at all. So if Congress says, here are the programs, and raise enough money, just enough money to do those things, why isn't that good enough? Because there, Congress has already decided this is what the program should be for, and we want you to collect this much money and no more. So I think that's really going to be, if there were one thing that is at the heart of the case, I think it's that. And it's always good when the big moments on the key themes seem to go in your favor. And then yeah, I think it was a good moment for us.
Let me make an observation. Again, we're assuming a lot here because it could come out the other way. But assuming that it comes out the way we hope, there may have been a real tactical error on the part of consumers research by going small rather than going big. The way they framed the case was, we win under the New Deal era decision standards of intelligible principle. This is not an intelligible principle. Some of the justices, most particularly Justice Gorsuch, who evidenced this very much an oral argument, doesn't like this standard. And there has been a lot of pressure to change the standard. The consumers research, I think, is less interested in the FCC and the Universal Service Fund specifically than it was in getting a case to the Supreme Court to make a broader point about changing the constitutional doctrine as it applies throughout the federal government. And they had a hard time demonstrating that Section 254 fails to meet that intelligible principle standard. They might actually have been better off going bigger and calling for the old standard to be changed or overruled, and that we need a new standard consistent with some of the writings of Justice Gorsuch in particular. They might have had an easier time. Instead, Counsel for Consumers Research wound up spending most of his argument trying to defend the indefensible, or what we think is the indefensible, about Section 254 being an intelligible principle. If he had set a lower bar, he might have had a better case. We'll never know.
Kristen.
Wonderful. Well, you guys are just raring to go. I love this. Jason, can I ask you just a quick logistical question, just for folks that might be wondering, especially if they just tuned in and they heard the oral argument. They might be wondering why there were 3 total attorneys that were arguing. So do you want to just address why that was the case for this particular oral argument?
Yes, happy to cover that. There were 3 attorneys, 2 on our side, the acting solicitor general for the government, and then Paul Clement representing representing SHLB and Andy's clients, and then his own clients, the industry associations. Because,
And by the way, let's just be clear, Jason, the acting solicitor general is acting on behalf of the Trump administration.
correct.
Be clear that they are advocating for the Trump administration's position.
Absolutely.
Yep.
And they're as we predicted from the last webinar, there are some ways in which her defense of USF deviated from what I think the Biden administration would have said to defend USF. That said, it was a very strong and resolute defense. So we were very pleased to see that. The reason that there were two attorneys arguing for our side is that we filed separate petitions for certiorari asking the court to take this case. The government filed its own petition, and then our group filed a separate petition. So it's technically, this was two cases being decided that are going to be decided together. And in those situations, the court is happy to hear from just one attorney if both, the parties in the two different cases think one person can cover it, but they are also open to a motion for a divided argument, which is what the Trump administration filed here. So it's a funny thing about the Supreme Court. This case was scheduled to be an hour long, and that there would be 30 minutes on our side. So the motion at the court said the government would take 20 minutes and Paul Clement would take 10. I think they both took about 45 minutes apiece because the Supreme Court does not care about its own time limits. They will ask you questions until they are done asking you questions. And so it can be really helpful to have two people able to make your case, either because there are different perspectives to try to give the different justices different ways to think about the case, or frankly, in some cases, just to kind of play cleanup. Even Supreme Court advocates get some things wrong. They may not really understand what's going on with a particular question, but the person who goes second and is just sitting there taking notes can say, okay, that's a point where like, I know the Chief Justice was really interested in this, and I'm not sure that the other attorney got the point. I don't want to overstate that here. I think the acting Solicitor General did a great job, but there were a couple of questions from the Chief Justice about kind of the history and the background. And this is one of those places where the acting Solicitor General answered the question in a particular way. But I think Paul Clement, who is, if there were any person who's going to channel how the chief would think about a case, it's probably him. I think he detected kind of the underlying concern that the Chief Justice had there. And he came up really ready to go to say, this is not a statute where Congress has just passed this in isolation. Universal service predates the 1996 Telecommunications Act by decades. And so if you, the Chief Justice, are concerned that Congress could take these same words and apply them to a new situation and just give limitless power to agencies, if that's the sort of thing you were concerned about, you should know that the way Congress was legislating here was against the backdrop of everything that came before it. That is the sort of thing that the Chief Justice often looks for in trying to understand the history and the context. And by answering a question that he didn't actually get from the Chief Justice, but that the acting Solicitor General got from the Chief Justice, it really highlights the benefits sometimes of having two people able to go. So that's a long answer to a short question, Chris, and that's why we had three people.
Let me add two non-substantive comments to that. First of all, when the United States is party to the case, they often do not want to share that argument time. But when the advocate is Paul Clement, they're more than willing to share the time. So that was a big help to us. And indeed, he did a magnificent job. The second point I would make is that the nature of oral arguments has changed since Chief Justice Roberts took over, and especially since COVID, when they were discussed in the pre-game show a few weeks ago. Post-COVID, they changed the formula. But under Justice Rehnquist, Chief Justice Rehnquist, when the red light went on, when your 30 minutes were up, mid-sentence, he said, "Thank you very much," and one sat down. They were by the clock. They were 60 minutes to the second. And he was rigorous about that. Your time is up, sit down. That has changed. And so that's why we got a 2.5-hour oral argument. And from a spectator standpoint, and I think also something from the standpoint of the justices, the current system works a lot better.
Wonderful. Well, thank you so much. I know some people are probably wondering about that, so lots of helpful context there. So we got this question in the chat, and I know this was a question I was wondering about myself. So it didn't seem like the justices spent a lot of time discussing the mootness question, and that was one of the issues that was presented in this case. Why do you think they didn't spend any time on that? Is this still an issue that could decide the outcome of the case? Jason or Andy?
Go ahead, Andy.
Well, it's an off-ramp. The court added it. All three of the groups, our group, the United States, and Consumers Research, agreed the case is not moot. And what that is about is hyper-technical to agree that nobody on this call wants really to hear about. But it presented an off-ramp. If the court wanted to duck it, and they didn't necessarily know at the point they were looking at the certiorari petitions where they might come out. The justices hadn't given a whole lot of thought. It was mostly focused on whether we should take this case, not exactly the details of it. My guess, which is all that it is that once they saw the merits of the case and saw that there was an outcome that was possible, mootness, they lost, whoever it was raised in the first place, it wasn't us, was the court, lost interest in that. So it was much more, I think, a safety valve they put in if they wanted to dump. And I think they will decide they don't have to dump.
Yeah, I generally think that's right. If there's one thing in this case that all the parties could agree on, it's that the court should not dismiss this case as moot. And at that point, somebody could ask all sides and just really argue with all of us, but I think they had bigger issues that they wanted to focus on.
Joey, did you have a question?
Yes, I think it's important. I want to make sure we get to the combination theory. Because there's been a lot of discussion about that the rationale the Fifth Circuit used upon rehearing, and it did get mentioned during the oral arguments. Jason and Andy, if you want to say what happened and what do you make from the discussion, or maybe the limited discussion thereof, of the combination theory.
Well, it was weird.
That's a very legal term, Andy. Thank you.
Circuit did was weird. They said, just to recap for everyone, we're not sure whether the delegation to the FCC under Section 254 is constitutional or not. It probably is unconstitutional, but we're not 100% sure. And we're not 100% sure that the sub-delegation to USF, which we haven't mentioned here, the other issue in the case subsumed within this was whether the FCC's creation and use of USAC to conduct administrative aspects of the program is constitutional. We're not 100% sure about that either, but taken together, we know the whole thing is unconstitutional. There's no support for that. And it was a crazy way to do it. One can speculate, or I will speculate, that if this was a way for Judge Oldham in the Fifth Circuit, who wrote the majority opinion for the Fifth Circuit, felt that he could make sure that this case went up to the Supreme Court. It's also possible that to get this was basically a one vote win in the Fifth Circuit. It was 9-7. So if one judge had flipped, it would have been 8-8, and we would have effectively won the case, because they would have stuck with the panel decision. So maybe he needed that to get his 9th vote. We'll never know. But whatever it is, Consumers Research, wisely, didn't really try to defend the combination theory too much, and they focused on each of the parts being unconstitutional rather than trying to defend that thing. And of course, it didn't seem dramatic. That doesn't make case law for the ages in the same way that the Supreme Court is interested to do. It could have been an off ramp again, like the mootness, but that's about it.
Yeah, I just building off of what I said earlier, it's very rare that you can infer a lot with much certainty from an oral argument. I think that's true here for the combination theory. So with that caveat out of the way, one time where you can know quite a bit is when the person asking the question says, I wrote the decision that you're relying on, and I don't think it means what you say it means. And that happened here with the Chief Justice and, in this case, Free Enterprise Fund. So the basis for the combination theory was, as Andy said, we think there's a constitutional violation here, probably. We think there's another constitutional violation here. And if you combine them, we know there's a constitutional violation. And the core case that the Fifth Circuit relied on for that is this Free Enterprise Fund case, which dealt with two overlapping layers of restrictions on the president's ability to remove certain officials. And our argument this whole time has been, that decision dealt with a particular context where two layers on the president might change what the president can do. But here you just have two kind of generally unrelated things and you're trying to smush them together. And the Chief Justice here said, like, yeah, I don't think Free Enterprise Fund really looks a whole lot like this case. So it seems pretty unlikely that given the lack of questions about it, the lack of attention on it in the other side's brief, and then that line of questioning from the Chief Justice, seems unlikely that we're going to get a decision that affirms based on the combination theory.
So I know that many of the justices expressed concern about the effect or impact of their decision. So we heard about the effect on the people, right, that benefit from the USF programs, and the effect on the court's other decisions. Do y'all want to offer some insight there as to why they focused on those two avenues of impact?
Sure. I'll start, Andy. Look, cover anything that I don't get to here. I think number one, it's a testament to the job that SHLB, supporting Amiki, and everybody else did in highlighting, throughout the life of this case, the importance of USF and the importance for stakeholders and the impact of a decision declaring this unconstitutional, what that would mean. So we had a lot of really great factual support at the court explaining the importance of the programs. And I think it was really another important point in the argument is that Justice Alito, who, starting premises, we think probably is not too sympathetic here, he asked the question of the other side saying, I'm very concerned about what happens if we declare this unconstitutional. Tell me what happens if we rule for you. I don't know that means that Justice Alito is going to uphold the Universal Service Fund as constitutional, but it shows that this has gotten through, that they understand that this is decades long of structures being built on the foundation of the 1996 Act. So even if it's not a formal part of the legal analysis, judges are people. They decide these cases, based on what actually happens in the world. That doesn't always lead to outcomes that we want, but it's important. And so I'm really glad that I think has gotten through. Another way where I'm not sure if it will, but it could be relevant to the case is a point that Andy brought up earlier. Consumers Research didn't ask the Supreme Court to overrule its precedent. They tried to, like as Andy said, kind of go small and say, even under your existing cases, we ought to win this case. If you are asking the Supreme Court to overrule precedent, you have to confront stare decisis, this idea that generally the Supreme Court should not change the law from its own, what it itself has decided in the past. One of the considerations for stare decisis is reliance. Reliance on what the Supreme Court has previously said the law is. So here, they didn't ask for anything to be overruled. That, as Andy said, might actually work in our favor. The concern that the justices have about the impacts and the fact that the other side hasn't really addressed that in a lot of detail, we haven't looked at what other statutes in the way that you would if they were asking for cases to be overruled. There would have been a lot more attention on not just the impact on USF stakeholders, but other government programs that might be unconstitutional if the law is changed. I think that generally helps us and pushes the justices away from making a big change in the law here. Say it again, we never know. It's dangerous to read too much into this, but look, this is an important case practically, and it's important that the justices knew that, and I'm glad that the questions came up. It's hard. Oral arguments are hard. You get hard questions. The attorney for consumers research tried to make some arguments to minimize the impact, essentially to say, even if this would declare all of USF unconstitutional, if it's so important, Congress will fix it. But I'm not sure that that really landed with the justices, that there would actually be a lag time sufficient for Congress to clean this up without some significant impacts. So I think, if I were him, I would have hoped that the justices would think, okay, Congress will take care of this. We can decide whatever we think the law is, and we don't need to worry about consequences.
Kristen's got another question from the audience.
Okay, so I do want to ask a question here really quickly. This is about what's happening right now. So Consumers Research is continuing to file challenges of each succeeding quarterly cap. What do we make of this, and what does this mean?
Well, let's that real fast.
Go ahead, Amy.
Each quarter is different, so that in terms of the fees, which are minute for the specific parties involved, each quarter they're paying fees for those 3 months. So there's a modest amount of money involved. So by filing each quarter as they have done, they're refreshing their claim. But once they got into the Supreme Court and started doing it, there's no real particular reason for them to keep on filing those things. But, and I will be cynical here, we don't know this for sure, but it is quite evident from the way Consumers Research works, the various things that it's filing, the law firm representing them. This is not a pro bono case. They're paid by the hour. And each quarter is another couple hours to do the same thing. And I suspect that nothing more than they've been doing it, so they'll keep doing it until the court decides it. I don't know. Maybe that's too cynical, but I don't.
Thanks for the perspective, Andy. So we're coming up on 45 minutes. I want to end with a final question, and then we'll wrap up. And this is for both Jason and Andy. When is the decision going to come down, and what should we be looking for? I mean, I know Andy talked at length about there are all sorts of different structures or opinions that could come down. It's not as simple as the court just says yes or no. There can be majority opinions, minority opinions, concurrent opinions, dissents. But just talk a little bit about, as we enter the early summer, when should we be thinking, when should we be looking for this, and what should we be looking for? Either of you can start. I'll start with Andy, and then I'll let Jason have the last word.
Well, by tradition, the court likes to finish by the last week of June, and on occasion it slips into the first week of July, and then they like to go off on their various summer benches. It could be that this term is going to be atypical because there's all of these very consequential cases making their way to the Supreme Court that really, as important as we think USF is, that go to the heart of democratic governance. And it's not out of the question that the court will wind up taking some cases after its traditional close down of oral arguments at the end of this month. Take a couple of cases to be argued in May and June, big cases. So that may push the term back and may mean that this could slip back a little bit further if they wind up sitting into July. But one can assume that this will be among the last cases to be decided towards the middle to end of June. And beyond the timing, there's just so many possible ways they could decide it. I really can't speculate beyond that.
Jason.
Yeah, I agree on the timing. just from the way the court traditionally works, this feels like a case that is in June and probably the latter half of June. It could slide into July. I think the court is probably a little bit loath to let cases go on that long, just by, as Andy said, tradition before they all go do their summer things. My hope is that we have a pretty straightforward, robust. Look, I'll take 9-0, but I'll take, you know, 5 or more, who think that Section 254 constrains the FCC under the court's precedent, and, you know, the way that the law ought to work, that is enough, and Congress has made the big decisions here. What I think might happen is, as Andy alluded to before, we might have a situation where 3 or 4 justices say that, and a couple of justices are a little bit more equivocal. Maybe they find little parts of the statute, like Section 254B7, not to get way down in the statutory weeds. There's one thing that the court asked about is the FCC's ability to identify new principles related to universal service. Maybe a couple of justices would say, we're not really comfortable with that piece, but everything else is okay. So we agree that ultimately this is constitutional as long as you take that part out. Once we open the door to, you know, little surgical maneuvers, this might not be a 6-3 case or a 5-4 case. It might be a 4-2-3 case. And in that situation, we're going to have a lot of reading to do fast so that we can figure out exactly what the future of USF is, what changes, if any, would need to be made, and what the impact is going to be. But fingers crossed for a shorter and simpler decision that upholds USF.
Well, I want to thank Jason and Andy, as well as my colleague Kristen, for being on this webinar. I mean, it is evident that we have the best legal minds on our side, and I'm really just proud that SHLB is, you know, leading the charge in the courts as a named party to defend the Universal Service Fund. So we have come to the end of our webinar, and I want to thank again our sponsors, Ready, Zayo, T-Mobile, and Cisco. And just a reminder that if you've enjoyed these webinars, we do urge you to consider becoming a SHLB member. SHLB is the leading national advocate for affordable, high-speed internet for anchor institutions and their communities. And as we've just discussed, there are many threats to the Universal Service Fund, to E-rate, to rural healthcare, to BEAD, and so much more. And that's why we're working hard, including through our upcoming fly-in, which is next week, where dozens of SHLB members are coming to Washington, D.C. to go up to Capitol Hill and educate members about how important E-rate and the rural healthcare program are to their communities around the country. Because we have to make sure that policymakers understand the benefits of these programs. And that's why we encourage you to become a member and join us in this effort. And for those of you who are already members, we first thank you. And we ask that you recommend us to your colleagues that they join SHLB as well. So we'll wrap here. Thanks for attending, and we'll be in touch about future webinars in the near future. Thanks again.